Right from the jump, we're diving into bond conditions, football schedules, and a judge who's clearly not in the mood for games. But here's the kicker. This isn't just about football. It's about freedom.
Good afternoon, Your Honor.
Good afternoon.
Joe Loudmouth. Hands in your pocket.
I'd be asking to adjourn the probable cause conference. There's still some discovery that's outstanding. I'm told that the prosecutor has that. I should have it very soon. And I would ask to address the condition of bond.
Probable cause conference, October 17th, 2024, 9 a.m. Yes, that's the bond.
My client is a football player at Community Christian College, and he has, I think, 6 games left in the season. One of those games is in Atlanta, Georgia. One is in New York City. So I'd be asking for the court's permission for him to leave the state to travel to those games, asking for the court to allow either the SCRAM tether to be removed Friday before and then put back on Monday with an ETG test.
What's he been doing all season?
He hasn't been playing.
So what is he? Is he set to play these games? I guess I'm trying to figure out what changed.
He's been getting me documentation to verify that he's on the team. So I wouldn't make the motion to amend his.
Notice what's happening here? The defense is scrambling, pun intended, to prove this guy is really a player. But in court, documentation isn't just paperwork, it's credibility. Without it, judges don't budge.
Bond until I was given at least some verification. So he's presented me with his class schedule, with his school ID, his screenshots from his the computer system that they use to communicate with the rest of the team, his schedule, his recruitment information. So now that I have that, I was comfortable making the motion.
I guess I'm just trying to figure out. He's on the team. Could have had that to you at any point in time. Hasn't been playing. What is now causing him to play now?
Well, we're asking. I don't understand the question, Judge. We're asking now because now I have the information to ask. He asked me about this weeks ago. I didn't have the verification. So he's been asking for permission to play. I wouldn't bring it to the court until I had independent verification.
So he sat out, what, 4 weeks, 5 weeks of the season. Has 6 weeks left. And now is going to play. That's what I'm getting at.
That's up. Whether he's going to play or not is up to his coach. But I'm asking the court for permission so that he can be eligible to do that.
Okay.
Can I respond, Your Honor?
Yeah, go ahead.
Thank you, Your Honor. As the court can see from the phone, this is an OWI causing death case, so it appears to the people that the defendant is at liberty at all and has a SCRAM tether is frankly.
And here comes the prosecution with the hammer. That SCRAM tether, the alcohol monitoring bracelet, isn't just a nuisance. It's basically the court's way of saying, we don't trust you unsupervised. The prosecutor calling it a gift? That's shade. And the judge is definitely listening.
Quite a gift, given the facts of the case and the circumstances surrounding it. Your Honor, the people are opposed to any removal of that SCRAM tether at this time. It does not seem appropriate to allow the defendant to do that. We would ask the court to deny this request. I just was able to receive the MSP lab report, and I just showed it to defense counsel after this case was called, so he hasn't had the opportunity to discuss it with his client yet. But the people are now able to tell the court that the MSP lab report reflects that the defendant's VAC at the time of the crash and death was 0.186.
I'm trying to understand. If I'm the coach of a team I got a player, hasn't played half the season. Something has to change that says now this person is going to play. Not just that he provided the information regarding that to counsel.
Judge, it's my understanding he's been eligible to play as far as his coach is concerned the entire time. What he needs is the court's permission. I believe he has been practicing. Is that correct? Have you played in any home games?
Yes.
So he has played. He just hasn't been able to travel. So at the very least, Judge, if the court's unwilling to remove the tether, I would at least ask if the court would allow him permission to leave the state for, there are actually 3 out-of-state games. There is one this coming weekend in South Carolina.
I may allow him to leave the state. I'm not removing the tether. I may allow him to leave the state, but I'm going to have to see a schedule. So understand this. I'm going to deny the motion. However, counsel, I would allow him to leave the state to play.
Judge, I can show the court a copy of the schedule right now.
I'm not going to do it right now. Prepare me an order with the dates that he's leaving. Get prosecutor to stipulate to those being the dates on the football schedule, and the court will sign off.
Thank you.
I apologize for adjourn date.
17th. Thank you.
Thank you.
Have a good day, Your Honor.
Thank you.
New case, new drama. And right away, we've got a defendant who's been sitting in jail for 230 days. That's nearly 8 months. Can you imagine the frustration boiling over? This is where patience meets desperation.
Just call the case. People versus Dolores Strickland. Yeah, relax. Go ahead, have a seat.
Ready, Judge. Torshell Feaster, Assistant Public Defender, appearing on behalf of Miss Dolores Strickland. Miss Strickland, please state your name for the record.
230 times Dolores Strickland.
Thank you, Judge. I have had many conversations with Miss Strickland, and we were working with the people, with Miss Tana, to try to resolve this matter. Miss Strickland had a particular offer she wanted requested. I asked Miss Tana for that.
Did you ask?
Miss Tana.
How'd that go?
She was not willing
Yeah, I didn't.
to give Miss Strickland the offer that she wanted. Then I sent Miss Tanha the mitigation letter just to make sure she had it, because Miss Strickland wanted you to have it and Miss Tanha to have it. I told her this was not the point for Your Honor to have a mitigation letter, but I did make sure Miss Tanha had it. And you're asking for another adjournment so Miss Tanha can consider the offer in light of the mitigation letter that I have made sure she had per Miss Strickland's request.
So, do we have the...
And also, can we do that as soon as possible? Because I've been in here, Your Honor, 230 days today, and I've got absolutely nowhere. And I also sent you the mitigation letter and a letter in the mail just recently. So you'll probably get that too.
Okay. I know you've been in a while, but I also have 3 cases. So that may be part of the problem.
Altogether, from what I understand,
If I might, Judge, Ms. Strickland is hoping for a resolution that will not include any type of probation.
Oh.
And that is not what is being offered at this time. And that is going to possibly be a hang-up to resolve this matter.
And Your Honor, I told him that I would maybe consider it. It depends on how long it would be. But however, I do have family in Florida, that Tallahassee, the hurricane, things like that I really need to get out to see if they're even alive or what happened to them, because I can't find nothing out in here. And I talked to them through Messenger. That's the way I stay in touch with my family. And I know they got hit. I just don't know how hard. And I can't get no information because the only person that I have here is my ex of 15 years and my other kids that, you know, I don't have their number right now either because I cannot get to their number, and I do not have phone, which I need to ask Your Honor, can I get my phone privileges back on, please?
I believe they were restricted because she had contacted.
Because she violated a condition of bond, so I revoked it.
Correct.
I was already punished for that, Your Honor, because he had them block his number. So that should have no problem of me calling my brother and trying to get help from him or, contact him, because that's who I was contacting. I wasn't contacting my ex.
Okay, Ms. Strickland. Now, a lot of these requests that you're making.
It's because I got nowhere.
Okay, listen. You need to talk with your attorney about them.
Your Honor, I have.
Do you listen to your attorney as well as you're listening to me? That means not at all.
I got mental issues that just like I'm overwhelmed, very much so, Your Honor. But go ahead.
Thank you. Talk to your attorney about these issues. He'll talk to the prosecutor. They'll see what can possibly be worked out, if anything can be worked out. I'm not reinstating your phone privileges. You violated that condition of bond. That will continue revoked.
Then I'll just continue.
Okay.
Sorry, Judge. If we could have an adjournment so that Miss Tana and I'm bad with names.
Miss Rizmersky.
Miss Rizmersky. I knew the first name. Miss Rizmersky could consider Miss Strickland's.
How much time will it take for them?
We only need a week or two, Judge.
A week, please, Your Honor. A week. Let's speed this up, Your Honor. I'm trying to. If you just read my mitigation letter, Your Honor, you find out why.
Ma'am, that's the problem. You keep doing things that your attorney says it's not the appropriate time. When I get that letter into my office, I'm going to tell you I am not going to review it because it's not appropriate for me to see that. If you listen to your attorney, maybe this would go a little bit smoother.
Your Honor, my attorney's not telling me what I need to know. I'm lost.
No, your attorney's not telling you what you want to hear. He's telling you what you need to know. You're just not listening, like you're not listening to me. These matters are adjourned to the 17th, 9 a.m. Bond continued. Thank you.
Thank you, Judge.
Here, you can do this.